My name is Paige Snyder, and I'm a farmer in Gainesville, adjacent to Manassas National Battlefield Park. My family has farmed this land for 65 years and 3 generations. At 63 years old, I still farm it. When the citizens of Virginia passed the eminent domain property rights bill 2 years ago, I thought I was safe. In the past 8 years, Gainesville has grown from a chiefly agrarian community to one of dense development and strip malls. When VDOT started planning the Bi-County Parkway through the battlefield and through several acres of my farm, I was astonished that VDOT could give away my land as a conservation easement to mitigate the damage that the 60,000 vehicle a day road would cause the park. I and my neighbors who joined the park on the National Register for Historic Places for our land's contribution to the First and Second Battles of Manassas. My family has fought long and hard at great personal cost for 65 years to preserve and protect the park and our farm. As you can imagine, it was bad enough that up to 40 acres of my farm would be taken for eminent domain. But that VDOT would additionally offer up my farm as a conservation easement without any notice to nor consent from me is unbelievable. Apparently, VDOT found the loophole in the law and can negotiate away our private property as a protection area in order to entice the National Park Service to provide federal lands for the road. In their negotiations with the Park Service, VDOT designates our land as conservation easements if we are willing. The catch-22 here is that we are being forced into agreeing to a conservation easement because we would have no alternative once our land is devalued and restricted. This is a precedent-setting taking, which, if VDOT is allowed, has the potential to affect Virginians all over the state. For me personally, what this means is that VDOT is subsidizing the road through a back door at my expense. I already have a cloud over my farm because of the planned road, but if I ever want to change my land use status, I will be unable to do so. Also, this immediately devalues my property, for which I am not recompensed, hence the backdoor subsidization paid for by me. I am not rich. My mother always called us dirt farmers. We have a history of working hard not only to improve our farm, but to protect historical lands. And I'm angry. How can we allow VDOT to restrict and devalue our land? Is Virginia a property rights state or not? 2 years ago, the voters told you in no uncertain terms that property rights must be strong and protected in Virginia. One of my neighbors is a 94-year-old lady. She wants to sell her property so that she can go into a nursing home. No one is interested in her property because of the clouds of the eminent domain and conservation easements. Please, put a plug in this property rights hole. Stop it before it becomes a matter of common practice. Stand up for your citizens, not for big government. And thank you very much for listening to me.
Good morning. My name is Philomena Hefter, and I live in Gainesville, Virginia. Thank you for the opportunity to provide testimony in support of Senate Bill 194. We need this bill to protect landowners from the unfair practice of inverse condemnation. The plans for the Bi-County Parkway in Prince William County were underway, and I request to become a consulting party to the programmatic agreement which was being negotiated by the VDOT National Park Service. I quickly realized there was a bigger picture and started to review both the process and the agreement and made numerous Freedom of Information Act requests. What we found was disturbing. It showed how VDOT had negotiated with the National Park Service to entice them to support the Bi-County Parkway. Only were they planning to close off Pageland Lane, Virginia 234 within the battlefield, and traffic calm US 29. They wanted conservation easements on adjacent properties within the Battlefield Historic District. The first mention of this is in December 7, 2007 letter from the acting superintendent of the Manassas Battlefield to VDOT. Let me quote, "The park would also like to propose that VDOT purchase conservation easements within the historic district. Acquisition of conservation easements on Pageland 1, 2, and Dunklin Monument Drive, they're all privately owned properties, would serve as mitigation for adverse impacts on the Manassas Battlefield Historic District. from construction of the parkway. On August 2011, Richard Walton, VDOT Chief Policy Environment, wrote to Steve Weitzel, Regional Director of the Park Service, and stated that VDOT would commit it to in order to construct the parkway. VDOT was, quote, VDOT was open to the form of mitigation as part of the Section 106 process as long as the commissioner did not have to use the power of eminent domain to acquire property for the purposes of historic property mitigation. We propose to provide funding to another organization or partner with particular expertise in land conservation through either fee simple purchase or purchase of easements and development rights between the one property owners. The FOIA documents went on in 2012. Secretary Connaughton committed $3 million, and there was a lot of discussion and emails. The quotes are, no, we have never done this before, never purchased conservation easements for mitigation for cultural resources. Wow, good deal. Now I ask who this good deal is for, not for the landowners. It saves VDOT money by not having to pay for eminent domain takings. The landowners are left holding the bag, and the properties whose value has been adversely condemned. Thank you for listening, and please support this bill to protect the small guy.
Good morning, my name is Mary Ann Gagnon. I just want to briefly say that this bill is not about three ladies from Gainesville, Virginia. This bill is about every relative you have and every constituent you have. This is a new tactic that the VDOT has come up with to try to negotiate away people's property rights in a 100-page legal document, which, so if you're willing to put 60,000 Google Trip highway through a historic district, then why would you use private property as a protection area? We need to have the rights, and so do the people of the state of Virginia have property rights, that if we want to change our land use, we can do this. Once this document is signed, ladies and gentlemen, our properties are devalued and inverse condemnation has taken effect, and that's why we need SB194 to give us the rights to go ahead and file for a lawsuit. I also just want to say that you're going to probably hear from the local governments about this is going to cause a fiscal impact. Well, you know, my question is this. Are you saying that VDOT and other agencies would think about going ahead and doing such a deal, promising away our property rights, and not realize that we've worked our lives for our farms and our properties all over the state of Virginia? This is part of doing business. If you want to build a road, you can't devalue people's property and then do the taking. Thank you so much. Please vote for SB 194.
Good morning, Josh Baker, law firm of Walden and Lyle. Briefly, what this bill does, as Senator Black has proposed, is it protects these owners when there's a promised future condemnation or acquisition of their property. It locks into place the date of the valuation for when the property is to be valued when it is eventually taken, will be the date at which the agreement is signed. That's the first part of this bill. The second part is equally as important. The second part closes a loophole that I don't think this body meant to have in our code, but it adds two little words in 25.1420. It says or damage, and what that is that is a protection for property owners when they're forced to bring an inverse condemnation action when the government hasn't acted correctly. The owner has to bring that action and say, you took my property. Right now, if a judge determines that the property was taken, that owner is fully reimbursed for their costs in bringing that suit as they should be. The loophole that you can correct today is that the words or damage were left out of that bill by accident. And this bill corrects it by adding those words or damage. A property owner who brings an inverse condemnation action may also be reimbursed for the cost of bringing that action if the judge determines that their property was damaged but not taken.
Mr. Chair. I have a couple questions, if I might. And I want to zero right in on this because I'm very sympathetic to the process you're describing, but I'm going to make sure I understand the sequence here. This Bi-County Parkway is controversial to begin with, even without the property rights issues. And I guess my question is, at what point do you see this inverse condemnation right attaching when there's an agreement made with the federal government regarding the battlefield, or when there's some type of master plan approved by the Prince William County Board of Supervisors, or when? Because there's going to be many stages if this road ever happens, but it may never happen.
Right now, the state has a signed document with the federal government to impose these conservation easements on those properties. And so, Senator Peterson, appropriate time for this to attach is at the time that that agreement was signed. And so I believe this bill would be intended.
Let me one further question, Mary. I see Hank standing behind you. Here's my question. What if the VDOT or Prince William County or whoever enters this agreement with the federal government, and I guess theoretically they have the preservation easements, but I assume that they're contingent on the road actually being built. Am I correct or incorrect?
Well, that is correct, but they are right now promised and funded to acquire these conservation easements across the properties in Gainesville.
Okay, so here's my question. Thank you, Mr. Chair. And that is, what happens if they make this agreement, and I agree it diminishes the value of the property, I get that, and then there's an inverse condemnation suit, and they make the payment to the owners, and then they don't ever build the roadway, or they never build the roadway, which again, is a very likely outcome. Do you see what I'm saying? Maybe Hank knows the answer to that.
I'll give them the power.
Yeah, Senator Peterson, you're conflating the two parts of the bill. One is simply a valuation issue. That is, if the planning and the announcement of the project drives down the value, so when ultimately the government comes and takes it, they need to give the value back when the deal was signed before the value started going down. That is a Supreme Court case, Pearsall, that this codifies Pearsall. The other thing is adding more damage is simply to correct a mistake back in the 70s when we were adopting the federal law. They didn't mirror our Constitution. Thank you, Mr. Chairman.
Thanks, Chairman. I have a question. Somebody, one of your comments. On line 22 and 23, right now the law is the date evaluation at the time of the lawful taking, or the time when the petition is filed. You added language for the day in which an action is taken, which substantially affects land. Now, what's the difference? And is there not now already, in case law, I know there's a case I run, having to do with inverse condemnation. Can you explain how this would change that, or add to it, or codify it, or what?
Certainly, Senator. Yeah, as Mr. Howell said, this does codify an old Virginia Supreme Court case that says that when the government takes proactive actions that devalue your property, you're allowed to go back and make that lawsuit retroactive for that. The issue here is that we've got a signed document that right now is committing the Commonwealth to purchase these conservation easements. And so but they haven't brought the suit. So right now, the way that the law reads is they have to wait for the suit to occur.
Well, this
That we got to bring that suit.
right, that's what I'm saying. Mr. Chairman, in Monroe, it took 10, 20 years or a long time. They said they were going to do it, they didn't get around to doing it, the suit was brought, and substantial damages were awarded. It seems to me that's exactly what's going on here.
Well, Senator Edwards, the difference in that case, that was that Clater case.
Right, Dr. Clay.
Yes, sir. And what occurred there was, that was a 15, maybe 20-year period of time that had passed. Here, the Commonwealth is acting much more quickly, and these folks are left without a remedy in the intervening time. And so what this bill does is it would give them the right to actually bring that suit. In Mr. Clater, in Dr. Clater's case, that was an open question, whether he was going to prevail or not. This bill would give property owners a ground to stand on, other than just hoping that the courts would interpret the old law.
What you're saying is this would clarify what you think is existing law, but make it more precise.
It would, Senator.
Thanks, sir.
I grew up, for the most part, on a farm on the fringes of the historic Green Springs District in Louisa County, Virginia. And probably once or twice a year, somebody would come knock on the door and ask my parents to move the property in the conservation district that was larger. My father, who passed 3 years ago, said he wanted to see that property stay the same forever, but he didn't want to encumber it with the burdens that would come with being in the conservation district. Ultimately, before his passing, my mother and father sold that property, and because it was not encumbered by being in the conservation district, did quite well. In 2 days, my mom will go in for surgery. The money that was made on the sale of that property by virtue of my father's decision will pay for that and create a circumstance where she's more secure as she ages. I want to point out to the members of this committee, and I look specifically, some of you who I know have read the Constitution and understand it, the Fifth Amendment of the Constitution of the Takings Clause, there should be no taking of private property without just compensation. And so when we force landowners, and that's what this does, into pushing a property into a conservation easement, we take value from those landowners, which I can tell you literally I just did a first-hand story on. And so I really genuinely believe that this is, if we don't pass this bill, we're begging for a lawsuit down the road. Because the money that's potentially never recognized by virtue of forcing these landowners into conservations that they didn't agree to, in my estimation, is a taking. The personal case says so. Now, and one of the ladies that spoke earlier, and I want to be brief, Mr. Chairman, I really appreciate your words. So, I have the emails, and I quote, "Wow," for our previous discussions, "Wow, maybe tomorrow will be easier." Did I say wow? So Virginia administrators of VDOT were shocked that they found this loophole, but the people who suffer are the people.
You understand?
Thank you, Mr. Chairman, very much. Thank you.
Council, we're curious about the comments. Williams?
Mr. Chairman, my only concern or question about the bill dealt with the language on lines 22 and 23, because the language seemed to, it is ambiguous. My questions, my prospective questions would be, what sort of action does the bill contemplate? What constitutes substantial effect? And the criteria guide use and enjoyment. Would this be historical use and enjoyment, a new use and enjoyment that is not going to be permitted? These terms and phrases appear to be what would be the subject of litigation. And so I wondered if the language could be tightened to address exactly what the patron and his witnesses were seeking to do. And so, for example, if the language referred to the date on which an agreement were to be signed between whatever entities were taking this action, that is, of course, more precise than simply leaving up to the courts to decide what is an action within the meaning of the bill. I noted that one of the attorneys referenced an old Virginia Supreme Court case. I think we're looking for the site now. If this language is drawn from existing law, and if in fact these are common elements litigated in these proceedings, then I have much less concern. This, of course, is not my area of expertise. All I can identify for you is that the language in lines 22 and 23 is ambiguous.
Council, the word substantially affects, does that bother you? How do you define substantially in this area?
Whatever judge is sitting on whatever day is going to make that determination.
Mr. Chairman. I think you understand the bill. Other people to speak against it, anything else to add?
If I could, and perhaps after the opponents have had a chance to speak, I would ask perhaps the courtesy that, with your permission, that we would then take it by to the next meeting and we can examine that language and see if we can bring a little bit more precision to it.
Thank you.
Mr. Chairman, I'm Sandy Cherry with the law firm of Randolph, Boyd, Cherry and Vaughn. I'm here on behalf of Norfolk Southern, which has the power of condemnation. In my private practice, I have for over 40 years devoted a substantial amount of my time to eminent domain, primarily for condemnors, but also for many landowners. The date evaluation is critical to every single condemnation case. An appraisal is only good for a single point in time, and therefore the valuation date needs to be fixed and certain. And as Mr. Benjamin observed, this language gives us a fuzzy date to be determined in the litigation itself. For the purpose of the appraisal, the appraiser needs to have a fixed and certain date. He needs to have it in advance of the condemnation. And although all of this has been addressed towards inverse condemnation to solve an alleged problem in Prince William, I believe, that I'm not involved in at all,
This definition changes the definition of evaluation of the data take in all condemnation cases, conventional cases as well. And there are certain circumstances in which this date could be applied in a conventional condemnation case, in which instance the condemnor's appraiser would not know the date of his appraisal until the litigation commences, which is impossible because he's got to make a bona fide offer.
I have a question. Would you suggest other language that would narrow the scope of this bill?
I don't have any such language, and we're opposed to it for other reasons as well.
I have a question.
Yeah.
On the current issue, Mr. Chair. On the case, Ronald declared case, and there are others, has the Supreme Court defined the time of the lawful taking? We know the date of the filing of the petition, that's easy. But what, because it's an order, current language, date evaluation means the time of the lawful taking by the petitioner. What does the Supreme Court say about that?
The time of the...
Such an inverse condemnation case.
That refers to the date that a certificate... I'm sorry.
Don't have a line of conversation between you and somebody
Yes.
Recognize the chair before you speak.
Yes, sir. Mr. Chairman?
You speak.
Yeah, thank you. Mr. Chairman, that refers to the date the certificate is recorded, the date of the lawful taking. The alternative date is the date of the petition is filed, and that refers to cases in which there's no quick take certificate, but it's a slow take and a petition is filed. Those are the evaluation dates under present law.
Mr. Chairman, like in the Clare case, who I was was there a certificate that was filed by, I think it was the housing authority? Is that the date, or do you know that?
I do not know in the Crider case. Ordinarily, redevelopment housing authorities don't file certificates of quick take, but some take the position they can. I would also point out, Mr. Chairman, members of the committee, that the issue of condemnation blight is already taken care of by section 25.1417A3. Here's what it says. Any decrease or increase in the fair market value of real property prior to the date of valuation caused by the public improvement for which such property is acquired, or the likelihood that the property would be acquired for such improvement shall be disregarded in determining the compensation for the property. You don't change the date of the valuation. You apply this principle and you disregard any decrease in value that's been caused by the impending project. It's been the law for years. What they're trying to do here, and I don't, what the lawyers are trying to do who try these cases, is to subtly change the definition of what is a take or damage. The language that they use substantially affects the use and enjoyment of the property by the owner is not the current standard for an inverse condemnation. I think that's the real purpose of the bill. The second thing that they're doing is simply adding attorney's fees to damage only, no take, inverse condemnation cases. That wasn't a mistake in the statute. That was adopted as part of the Uniform Act in 1972 and has been our law ever since.
Sure. After listening to your testimony, I want to know whether placing a property under a conservation easement generally reduces the property value, that is the market value of the property, rather than when it's unencumbered.
Certainly can't apply that to every situation and every property. Sometimes it would and sometimes it would not. If the property otherwise would have a different higher and best use, a commercial or other higher and best use, certainly the imposition of a conservation easement would reduce its value. But if the property is located in a scenic area of the mountains and would never have been developed anyway, the conservation easement may not impose any reduction in value.
Mr. Chairman?
One follow-up? Sure. Is it then normal then to force a property owner to place property into conservation easement? Is that normal? To force a property owner to place a property into a...
I represent not Norfolk Southern. I don't represent the Highway Department with regard to this matter, and I don't know any
VDOT.
Well, Mr. Chairman, Mr. Chairman, isn't it true though, if a condemnor is gonna place a conservation easement, that they have to pay the landowner for the basically taking the development rights away? And there's monetary value there.
If the condemnor itself imposed a conservation, took it, an easement, certainly would have to pay the value of the easement and damage to the resident.
Thank you, sir.
Mr. Chair, Joy Maxwell from VDOT. Pretty much, for the most part, VDOT's concerns are the same as those voiced by Mr. Cherry. The concern we have, too, is primarily this language, while it speaks to the date of valuation, as Mr. Cherry indicated, our concern is the vagueness of the language, number one, but number two, we may actually be broadening the type of, or the matters for which compensation can be granted to property owners.
Do you have any suggestions?
No, Mr. Chair, we don't, primarily because we did not know what exactly the intent was. And as Mr. Chair noted, we felt that if the issue is valuation, that is covered by another statute in the law. And so our concern here was, given that statute and the fact that this language is somewhat vague, we're really widening or broadening the scope of what might be property interest that could be compensated for. Thank you, Mr. Chair.
Mr. Chairman, I'll be brief. John Russell on behalf of Virginians. I would like to associate myself with Mr. Cherry's remarks. Certainly, we oppose the bill. We don't think it's appropriate. I would point out the language on line 23, setting the standard now for the data evaluation of something that substantially affects use or enjoyment. Virginia, for years, has had a standard that there must be some actual taking or some physical damage to the property in order to justify compensation. This would throw that out the window and set up a whole new standard for taking, and we do oppose the bill.
Do you have any language that you would suggest?
Mr. Chairman, if the purpose of the bill is to deal with condemnation of blight that's dealt with elsewhere in the code, we don't need a new statute to do that. I don't believe the bill is necessary in order to address the issue that parties have raised in the testimony.
Thank you.
Board, Mr. Chairman, members of the committee, Chip Dix on behalf of the Virginia Telecommunications Entry Association, and we oppose the bill for reasons already stated.
Thank you. Sometimes I'm going to let this bill go over till Wednesday, and if you have any arguments that you can submit to us in advance of that, we will consider them. It's a very important issue, and questions have been raised as to whether or not this language can be narrowed to accomplish what you say you want to accomplish. But
Thank you, Mr. Chairman. I appreciate your courtesy very much. We will we'll work on the language, see if we can get it in a format that will be a little bit
if you
more.
communicate with Mr. Benjamin in advance of the answer, then that would help us.
Okay, thank you.